Can you walk away from a firm real estate transaction? This is the exact question I'm be going over with my lawyer, Eric Lee from Garrison Law, in this episode of Prime Privacy. Make sure you stay tuned to find out if you are caught in this situation, what you can and cannot do, and some non-legal recommendations Eric is going to give you. Stay tuned. Promise you, it'll be worth it. Good day, Toronto. Welcome to another episode of Prime Privacy TV. So glad you joined me here today. We've been graced by my lawyer, Eric Lee from Garrison Law, to talk about some of the shenanigans that are happening in the real estate market about people potentially wanting to walk away from their firm transactions. So, Eric, welcome to the show.
Thank you for having me.
Yeah, for sure, man. I appreciate your time. So I guess the biggest question everyone's always wondering about is right now, because the market's slowing down and prices are coming down, can you walk away from a firm transaction?
Well, the short answer is no. So I think one of the things that we're going to cover today is how to protect yourself if you're a seller, and some of the things to consider if you're a buyer if the deal starts to go sideways. I think a good starting point would be maybe to discuss, well, from the buyer's perspective. From a buyer's perspective, I think one thing that I'm sure Zen you can comment on is that right now we're seeing a lot of appraisals maybe not coming back the way that the purchasers are expecting. Other issues with financing that are maybe perhaps coming up last minute, and it's almost to the point where even private financing might not be an option. And it's obviously a serious consideration that clients have is, well, should I walk away from the deal? And if I do, what are the consequences that I might face? Generally, if something comes up like that, my first piece of advice to a client is try to close the deal no matter what, because in short, your deposits are going to be at risk. There's also the risk of damages that you might be exposed to. And I think some of your viewers might be wondering what risks might entail a breach of contract if you're not able to close. So I think the first thing to talk about would likely be the issue of the deposits. So in case law, when there's ever litigation, courts have commonly held that essentially the deposits are fair game for the seller to take, unless they are insanely disproportionate to what they may be giving up relative to the purchase price. What I mean by that is if you have $1 million property and you have $150,000 deposit, even though you might be able to argue that your exposure to damages may not come to that amount, the courts have consistently held that that in itself is not a reason for the full deposit not to be forfeited. Now, compare that with maybe an instance if you had given a $500,000 deposit against $1 million purchase price. That may be seen as what we call an unjust enrichment. Maybe the seller is unreasonably benefiting from the purchaser breach. But by and large, I guess the rule I would use is generally if you're looking at some deposit that's sub 20%, that is all really fair game, even if it may seem like an exorbitant amount for clients to stomach.
Yeah, that makes sense. And I forgot to kind of throw this in. Anyone watching this is not legal advice.
Yes. Exactly. If you do find yourself in a dispute within your transaction, I do recommend that you seek out legal advice or seek counsel of the lawyer that's acting on your transaction. These are just a few tidbits that we've encountered in our practice that you may want to keep in mind or perhaps discuss with your lawyer.
I figured we just slide that in. This is just dudes talking about real estate, okay?
Yeah. More so observations from what we've been seeing over the past few months, for sure.
Like one of the things I was gonna ask you about was a lot of people always think they can just walk away and leave the deposit intact, but from the REBA 2000 and that we have, right? Actually, as our brokerage, we can't release those deposits held in trust under only 3 situations, right? So you got mutual release, completion, and court order.
Yes, so that's correct. So what I find is a common misconception with a lot of people involved in transactions, more so on seller side, because people think that, well, as soon as the buyer breaches the agreement, all of a sudden the seller is immediately entitled to the deposit. Now, what I was talking about earlier in terms of the common law is that it's well established that if you go and sue, it's going to be, at least generally speaking, a relatively straightforward process to get the court to rule in your favor and get those deposits released to you. However, the court process can be quite lengthy and time consuming, and also very expensive. So you might be stuck in litigation for upwards of a year, even just to get those deposits. So it's not like if you're a seller and then immediately after the purchaser breaches, your lawyer sends a letter to the brokerage, and then you're going to get those deposits right away. So if the buyer refuses to sign a mutual release at the end of the termination of the deal, then you have to sue the buyer in court in order to get those deposits. So one of the kind of tragic things that we've been seeing is a lot of people, and I know you don't generally recommend your clients do, is they try to sell and buy on the same day. So when a deal falls apart, sellers that are also aiming to purchase something, contingent on their sale going through, this causes a lot of havoc, because now it's not so much a matter of, you're not going to get the deposit in a matter of days or weeks. You could be looking at months, if not years, until that litigation gets resolved.
Yeah, it gets really, really sticky. And then the worst part is we've seen these things like daisy chain on, where one A needs B's money, B needs C money, and C needs D money. And it's just like one giant chain of everyone trying to close 9 properties at the same time on the same day. It's just gong show.
Yeah, that actually brings me to another consideration from a purchaser side, which is the risk of damages. So when you're buying, and if you're not able to close, it's not so much just your deposit that's at risk, but there's a number of other things that you should keep in consideration that you may also be responsible for if you breach the agreement. So one of the big ones that kind of came up when we saw a bit of a downturn in the last decade, when prices were dropping, I want to say, 20 or post 2015, where prices had dropped a lot. The people were not able to get the appraisals they wanted. And then, builders started suing a lot of buyers. So what we saw in those markets in those conditions when there was litigation, was that the sellers were able to actually recover judgments for the difference in the purchase price. So if they had originally signed an offer with the purchaser for $1 million, they were able to relist the property and resell for $800,000. That difference, the $200,000 loss, which the seller could claim as damages, the buyer in turn had to come up with that money.
And that's something that I remember seeing in 2017, especially in the York region, right? Where you feel like you walked away and you left, call it your $150,000 deposit to the builder, but then a little bit later when they sold it, right, and you can prove damages, right, which is the delta between what you bought it for and what the builder ultimately sold it for, you got sued for the balance of it, and you had to defend yourself. And I don't see how you would have much of a case.
No, yeah, exactly. And so there have been a lot of rulings kind of supporting that logic from the courts as well. So that was really established over the past few years. I think that's kind of clear cut thing, and something definitely for purchasers to be mindful of if they're not able to close. Just speaking on terms of the costs and additional damages, what we're talking about with this daisy chain of transactions falling apart. If the seller has moving costs, or if they are now, because their sale or their purchase can't go through because you've breached, and there's a bunch of legal fees, or they're carrying the seller's mortgage interest on the other end of the deal, you're going to be responsible for all of that as well. Now, and when you're dealing with, you need a little bit of time, you can get an extension. Those are all reasonable costs to be carried over. But as you might imagine, if that deal falls through completely, then you might be exposed to a significant amount of damages.
Yeah, and I think the key thing is, if you think you're trying to walk away from a deal, it's just not the deposit, because once the dust settles and people have losses, they can come after you because it's your fault.
Exactly. What I find, unfortunately, is that it oftentimes ends up being a very emotional exercise for the purchasers and sellers involved in the transaction. So even when I try to counsel some of my clients in terms of what is the most economically feasible or practical solution to move on, because in my experience, it's not something that you want it to linger and be caught up in for months. And most of my clients end up regretting litigation after the fact, unless there's substantial damages to be held. But sometimes I find that it ends up becoming more of a personal vendetta than anything, and that when that lack of logic comes into play, it definitely makes it difficult for both parties to resolve the dispute.
I find once, nothing against lawyers or anything, right? But once lawyers get involved, it gets super emotional, and it's just kind of like an ego fight. It's just not, there's no logic to it. And you can't even say, hey, you're in the wrong, and just move on. They're like, no, I'm going to fight this to the death.
Yeah, no, that we've definitely experienced that before on a lot of deals. We worked on together as well.
And you also, I think, have to keep in mind, in our legal system, the loser has to pay a portion of the winner's legal costs too, and that stuff adds up.
Yes, exactly. And so, with the litigation, because what I find is that, and I guess I should clarify this, with mutual leases, sometimes there is a misconception that it's an all or nothing exercise, when in fact it's not. So, for those viewers at home, just kind of a high level of what a mutual lease is it's a document signed between buyer and seller, where the parties agree, subject to whatever terms you reach, that the parties will essentially walk away from the matter and then essentially promise not to sue each other moving forward. Now, the terms of that mutual lease are not necessarily arbitrary in that the seller has to retain the full deposit. We've seen cases where there's $100,000 deposit. The buyer wants to retain some of that, and then the sellers want to cooperate a little bit, and so the seller is willing to walk away with 75,000, leave a little bit for the buyer. And in those instances, I really encourage people to be kind of practical about it, and so within an economic perspective, as long as you're getting substantial value, I think for your breach, it's better to move on as opposed to having that deposit get tied up in litigation for a significant amount of time.
But this is where things are different depending on the market condition, right? Because when the market's hot and we sell something and someone doesn't close, and we're like, well, the neighbor just sold for whatever we sold plus 50 grand. We're like, fine, we'll release, we'll resell this, right?
Yeah.
And then we've always tried to negotiate, like we take a little bit of the deposit, right? And that's fine. But in a market that's falling and the seller's like, well, I want that money because I know I can't get that, then that's kind of when we run into kind of a sticky situation, right? So in instances where we represented the seller, if they needed more money for somewhere else, then the buyer has leverage to be like, hey, I know you need the money. Let's just try to work something out and get like a price reduction, an abatement, right? But in an instance where like they just want maximum money, then that's when things kind of get sticky. And I guess if you're the buyer in that situation, you got to see what you're content with as a loss versus like what you appraise at, because that tends to be the issue with the slowing market.
Exactly. And with the falling market, the exposure damage can wildly vary because at the end of the day, we can't foresee exactly, where prices are going to trend in the short term, especially, right? So kind of expanding on that, like in the short term, and I use the term short term because what we're looking at often is the seller, when they have to terminate the deal, they have a duty to mitigate damages, which is essentially one of the obligations is to relist the property as soon as possible. So if you sell it within, this time period where the prices are continuing to fall, you might actually end up worse off than if you guys waited it out. But generally, the courts expect you to list the property immediately. And whether or not that ends up kind of being a negative outcome or beneficial to you, we don't really know. Now, when there's a lot of uncertainty like that, those are one of the rare instances in which I would recommend that a seller perhaps not accept a mutual lease and consider litigating, because we don't know at that point if the deposit is actually going to be substantial enough to cover off the damages that they might face from the price drop that they would encounter trying to relist the property.
Yeah, I guess if prices drop 10% and you bought for $2 million, that's 200 grand, and they only got 100 grand in deposit, you might as well litigate.
Exactly. We've seen it a lot on purchase transactions with builders. So we've had a client where she asked us to kind of negotiate a mutual lease. She had given her first deposit. This is a pre-construction, so they're staggered over a couple months. And so after the first deposit, she got cold feet, and she contacted us to try to negotiate something with the builder. So she gave the first deposit. She asked us, well, if we're willing to give the second deposit, can we just walk away from the deal? And the builder said no. And the deposits were quite substantial, and so of course the client was confused why the builder was not willing to allow for this, and they came back and said, well, you have to give us all the deposits that were due in order for us to release you. And in those circumstances, as unreasonable as they may seem, we are, at least in the present moment with all the interest rate hikes, kind of in a bit of an uncertain area, right? So the builder has no idea whether or not their exposure is going to 50,000, 100,000. It could be significantly more. So meanwhile, from one party's perspective, it may seem like the builder's getting this huge windfall because of the uncertainty of the market. The builder's not going to be one to suddenly just say, well, here you can walk away. They want to protect all their rights that they have under the agreement.
Yeah, of course. And I mean, like, if you ever try to negotiate with builders, like, they got teams and teams of lawyers, and pre-construction documents are just like pages and pages thick. And the problem is, like, even people buy pre-con, like when we're doing a lot of it, like, no one even gets the lawyers to review anything. They're just like, oh, okay, we're good. And they just walk away, 10-day cooling period's over. And then they realize when the market turns, like, oh, crap.
Yeah. We try to, when we do agreement reviews, there's a lot of disclaimers I even put in my comments, because there are so many things, especially with condominiums, that a lot of them are just forecasts. We don't know actually when the condominium is established what quality of property management you're going to get. Construction quality, everything can vary substantially, and the wording is intentionally vague to give builders a lot of protection from exposure due to misrepresenting something potentially. And so while we can say, okay, we can cap development charges, free assignment, interim occupancy, right to lease, those are common things that we try to look out for, especially with investor clients, things of that nature. But in reality, there's just so much uncertainty with them, and they're very one-sided. And I think a lot of people who are very eager right now to get into a real estate market that for first-time buyers, it seems like it's quickly becoming out of reach more and more every day. And so, they just go ahead and sign an agreement, but then, not fully aware of what they're actually getting themselves into.
Oh, yeah. I mean, there's also the potential of, they don't get satisfactory financing, right? And they don't build the thing, or they hold you up and say, hey, you got to pay more, which, like, I can see why, because, like, if they can't get the money or costs have gone up and they can't build it, right, they're not going to build it and just cancel the project. But it's never written in that manner. So yeah. There's just too much risk with pre-construction, especially when you have that premium baked in of like 20 to 30%. And I've been saying a lot, like, if the market trades sideways for 2 years, and instead of it going up 6% a year for 5 years for 30%, you're now maybe up 25%, and then you pay 30%, and now you're at the risk of underappraise. And in my mind, I'm just trying to go through the thought process of what happens if systemically entire condo building underappraises in 5 years.
Yeah, and it can very well happen. We've seen it before. Back just a few years ago, I think you and I had a conversation about a year back, just with
this one.
So it's all coming back to me. Yeah, and so we saw. I had a client. They'll ask me and say, "Look, like, your units are like the comparables or the appraisals are coming 100,000, 200,000 under. Can you do something about a price reduction?" And they might come back and offer you $25,000 or $10,000, but in reality, for people that are cutting it close, just barely being able to afford these properties in the first place, with that kind of financing, you're not going to be able to close, and really all of that ends up falling back on the buyer, unfortunately.
Yeah, and that's where, like, when the market is kind of going up, everyone's frenzied and FOMO buying into stuff, and they don't think about the potential downfalls, right? And when the market turns, everyone just needs to find someone to blame, and no one takes responsibility of saying, "Oops, I made a mistake."
Exactly. Just to expand on another point, just before it, I forget. Just from a seller's perspective, with all this talk of a downturn, is actually one critical thing I think that's important to acknowledge with deposits. So when we're talking about how deposits are treated, you're mentioning, when the funds are in the brokerage, it's sort of restricted. There's only really those three ways that you described in terms of getting them out to the seller. Those same restrictions don't necessarily apply to lawyers' trust accounts. So what we actually do as a general strategy is that if there's a delay, let's say a buyer is asking for a 1 week extension. We've seen extension requests for upwards of 2 months on some things right now. And when you're dealing with that kind of extension, you really don't know what's going to happen in a few months. You don't know where the market's going to turn. You have no idea if the buyer is going to be able to come up with financing at the end of the day. And so what we generally would do for our clients is actually have them move the deposit from the brokerage trust account into our trust account.
That's part of like the agreement to give the extension, right?
Exactly.
And then that becomes a direction for the listing brokerage to move it to yours.
Exactly. So it would basically be an extension condition. So saying that, subject to us giving you this extension, this is something that we would require. So prior to us, confirming in writing that we agree, we would actually have to get the signed direction to the listing brokerage signed by both buyer and seller, authorizing the transfer of the funds over to us. And that's important because, let's say you do give this, 2 months is a lot of time. We've seen longer. It's a critical period in which you could potentially be reevaluating your options, relisting the property. You're giving a large grace period to the buyer. But in doing so, you're also exposing yourself to a lot of risk because, again, we don't know where the market's turning. You could be doing something else with the property. In doing so, let's say those 2 months goes by, the buyer can't end up closing. Now you're kind of stuck at square one where you still have to take all these steps with the brokerage and suing this buyer and whatnot if they're not willing to sign the mutual release. However, if the funds are with your lawyer in trust, and we've essentially agreed in writing that it will become non-refundable and immediately released if the deal is not closed on the extension date, then there is at least some certainty that you're going to get something once that extension date comes and goes if the buyer can't close.
Yeah, I think we've have asked for extra deposits to be released immediately to the seller for extensions to protect some of our clients before.
Yes. So I guess the most common ones would be either the money. In some cases, we've asked exactly for the money outright to be released as of the extension date.
Yeah.
Or sorry, the original date, closing date. So saying that, if we're going to give you the extension, this 50,000 that's held by the brokerage goes straight to the seller right away without delay. And then also any additional deposits, we don't recommend that they go to the listing brokers. They should be made to the seller's lawyer's trust account so that they can be immediately released if there's a further breach.
Yeah, I even remember sometimes, depending on the office, processing the money out of the trust account takes some time at the offices too.
Yes,
so there's delays. Like even like especially like big volume brokerages, it can get slowed down by like a week or two.
Exactly, and it's critical because we've seen cases where with these kind of selling a buy arrangements, sometimes they're pushing for extensions on their purchase, right? So they're also incurring a ton of fees to push their purchase down the road. So if that deal falls through 2 months from now, it's going to be even worse for you as a seller or as a purchaser if your sale falls through at that point in time.
So I get the kind of ultimate goal for anyone in that situation is move the money out of the brokerage's trust account into the lawyers so it doesn't get stuck there and you have to litigate to get it, because you would at least have some kind of way to recoup the costs.
Exactly.
Yeah.
And we've seen actually a lot of purchasers lawyers become hesitant, and at that point you're able to kind of actually gauge how serious they are or their capabilities, whether or not they're going to be able to close on the extension date.
Yeah. Because like once you're like, hey, your client's going to lose the money, and they're like, then you're like, okay, these guys aren't going to close.
Yeah, because what people underestimate is that a lot of people don't have the appetite for litigation at the end of the day, so they will defer to the mutual release. And sometimes buyers have an inkling; they know that I still have some leverage if I'm not willing to sign that mutual release. I can get away with something because I can make it difficult. The seller has to sue me to be able to get that deposit back. And so, they'll agree to whatever ridiculous extension terms that a seller might levy, knowing that I still have a small bit of wiggle room potentially that I can leverage to, get some of my initial deposit back. But once it's all free and clear into the seller's lawyer's trust account, as long as the arrangement's there, then that's all fair game, and there's a lot more risk or skin in the game for the buyer, and you're able to gauge how serious some people are or not.
Oh yeah, of course. And we always know there's always someone who's overly wanting to be litigious, right? And they want to just fight tooth and nail and kind of just drag everyone down with the ship.
Yeah, exactly.
Yeah. So I think it's more like if you have a good lawyer, you got to know the law and what you can and cannot do and just kind of gauge the other party, right? Because if you're the seller and you need the money to buy something else and you're on the hook, like the buyer, depending on their motivation, may have some leverage on you, right? Because now you are breaching the other contract, which, I mean, ultimately you as the original buyer are going to have to pay the damages, but it's just an uncomfortable situation for the seller.
No, exactly. And I can't stress enough that the clause, there's a clause in the standard form ORIA purchase agreement that says that time is of the essence. So really, if you're late by a minute, no one is obligated to give you any kind of extension, even as unreasonable as it might seem. So we typically recommend clients try to preserve a deal where it's reasonable, but just as you're describing, depending on how certain parties conduct themselves, you're able to kind of fish out whether or not they actually are reasonably expecting that they can close. And I think that's important because really, when we're dealing with these time is of the essence clauses and just kind of the way the market is working right now, every day matters, whether or not you're buying something else or not, because opportunities abound, and you can lose out substantially if you're giving a bunch of time to a buyer that actually has no reasonable expectation of being able to complete the deal.
Yeah.
So there should be a lot of, I guess, the thought put into whether or not to grant an extension, because I think people give them out a little bit too laxly, frankly, in my opinion. And sometimes, if you're asking for 2-3 days, that's one thing, but a lot more thought should be put in when people are asking for weeks and months. You have to ask yourself, where am I going to be in that time if the buyer can't come through, and what are my rights at that point in time?
Yeah, because when I look at this, I'm like, okay, well, if these guys can't get financing because they underappraised, there's only so many ways you can get the money, right? And I think I made a video about like, if you're underappraised, the quickest one is run to every single bank possible, open the biggest line of credit they'll give you, and just pull it all out, right?
Yeah.
That's the easy one. And so that take you like a day or two. The next one is like you go B lender, and that's like what, a week to process now?
Yeah.
And then private is what, 48 hours? So anything more than that, like, smells fishy.
Yeah. I've seen people be able to close privates same day. and so, definitely not like, my recommended first choice because of the high interest rates that private lenders usually carry. However, when you're looking at your potential exposure to damages, especially in a falling market, that should be something, I would say, give some consideration to. And to that point, I think because there's so many options available to purchasers, and not to say that, as we acknowledge the high interest rates and commitment fees and things like that private lenders or sometimes even some B lenders have, not to say that that's necessarily desirable by any means. The fact that we know that there's these options available to them, if they're electing not to go ahead with them, that does kind of give you an inkling of how serious are these buyers with closing. I understand everyone wants to get institutional A lender to minimize their rates, but if they're taking it seriously and they understand the repercussions, they're going to close first and worry about those things later generally.
Yeah, but most people don't, and all they're concerned about is I want to get the A lender rates, and then ego gets in the way, and then things get litigated afterwards.
Exactly.
Yeah.
And it ends up.
Go ahead.
Sorry. I was just gonna say, like, when that deal does blow up, though, then I think a lot of times, unfortunately, the buyer, only until you get to that point, the buyer realizes, hey, I may have made a mistake. I shouldn't have, pushed it. Maybe I should have been more accommodating, taken the kind of plan B or plan C financing and went ahead and closed the deal.
Yeah. And this is where, like, and it's normal. It's human nature. Like, I'm guilty of it too, where sometimes you don't, know the mistake you made until you made it, but you won't make it next time, right? But when you're transacting in real estate, and often sometimes with our clients, buyer and seller, they do it like once or twice a year. And when you entrust it with like the wrong people and you get the wrong advice and you don't understand the repercussions, things get really messy.
Yeah.
So,
unfortunately, there's a lot of people in the industry, broadly speaking, that they're not giving kind of informed opinions, or they become messengers without actually giving their comments. There's a lot of trust placed upon real estate lawyers as a profession and upon realtors as well, and it's important that whoever you're seeking counsel from, you're kind of getting the full breadth of all the consequences and all the even the potential upsides, right? Because I think when you're making such a substantial financial decision, you have to make the most informed decision possible.
Yeah, absolutely. So what we're both trying to allude at is not trying to pump ourselves, but just get some proper representation, whether it be your lawyer or your agent, because this is when a market is always going up. everybody looks like a genius, right? But it's the people who've done this long enough, where we've seen the catastrophic things that can happen, is where we can kind of guide you on how to navigate this properly.
Yeah, and there's also, from my experience in my practice, there's kind of what we see in terms of the letter of the law. And I will always advise my clients, look, these objectively, if I look at case law from a regulatory perspective, this is what you have to do. But there's also the practical or business ramification side of things that you have to consider. Sometimes the thing that makes the most practical sense or business sense, may not to say they don't line up, but you have to kind of give consideration to both aspects of it, before deciding what to do.
Yeah, because if you can walk away from a deal and say you lose your deposit versus you lose your deposit, pay their legal key, go through litigation, and get sued for damages because they can't sell for what you bought it for, it's a bigger loss and it eats up like a year or two of your life.
Yeah, so it's like with that latter example you gave, you could that would be me advising you your full rights that you're entitled to under the agreement, right? But whether or not you actually want to go through that is a strongly personal consideration. So.
Yeah, exactly. And this is where it comes down to a lot of people's personality, whether they can stomach it or not, right?
Mm-hmm. I think there's, generally with transactions, unfortunately, it's not till, these deals go sideways that they, especially with first-time buyers or first-time investors, even, there's a lot of panic. And it's really important just to kind of try your best to be level-headed, and then lean on the experts that you've hired to help you guide you through the transaction. And also, I think to that point, it's so important to have not just a good realtor or lawyer, but also important, I think everything is important. Making sure that whoever's helping you with your insurance is on the ball, whoever's dealing with your mortgage. Because even when deals don't go through, you should be aware early on. You want to have a mortgage advisor, for example, that's able to kind of give you a heads up on what's going on. So if you need to arrange for alternate financing, that's something that you have ample time to sort out.
Yeah, and these are things that realistically you only learn from having gone through it yourself, and then you realize all the potential pitfalls and potholes that you could run over.
Yeah, I think people don't really, especially with people getting into their first few properties, they don't really grasp how many kind of as you're saying, pitfalls, but sort of just knowledge gaps too. Because what you'll find is with these various areas relating to a deal, not every professional is going to know what the other person is doing. So,
well, yeah, if someone who just got their realtor license in the last year, they've only been in a bull market.
Yeah. Exactly. And so, like as you're saying, everyone looks like a genius when everything's working out, but when the deals start falling apart, that's where you're going to be best served by a realtor or any other professional involved in your deal that's had the experience, seen the deal go sideways, and knows what to do.
Yeah, for sure. All right, Eric, this is very helpful for everyone watching. I'm going to put your contacts flashing on the screen and in the description below. Eric Lee of Garrison Law. If you want to contact him for any real estate help, please do. Do not contact me about if you want to walk away from the deal. Unfortunately, I cannot help you. You've already made the decision to do so. Talk to Eric. Is there any final remarks you want to leave for everybody?
I think if there was one piece of advice I would give, again, not legal advice.
Recommendation. Non-legal recommendation.
Exactly. I think really whatever decision you make, and it's just something we touched upon earlier, is try your best not to make the emotional decision. Because what we've seen is that when one person does something out of spite, it just escalates the situation for both sides, because you can't expect for you to do something out of spite or do something malicious and the other party is not going to respond the same way. And frankly, when these deals are at stake, you're talking about money that involves people's livelihoods often. And, I don't think it's in either party's interest to jeopardize that, between seller and buyer. And it's best just to, be realistic and practical about the situation. And really just when you're speaking with your lawyer, the lawyer that you retain is going to be mindful of what it is that your objectives are, right? And so it's best if you try to remain level-headed and kind of instruct your lawyer accordingly, because that will allow him or her to do their job more effectively as well.
Yeah, that's some solid non-legal recommendation. All right. Thank you, Mr. Lee, for coming on, and I will see you soon.
Thank you for having me.
Yeah, take care, man. Take care. Bye.
Cheers. Bye.
Make sure you give us a like for putting this together for you and subscribe to Prime Property channel, because I'll bring in a lot of my professionals I work with to kind of give you an idea of all the changing landscapes that are going to happen. If you have any recommendations or any kind of advice from other professionals you want me to talk about, let me know in the comment section below. I'm more than happy to kind of entertain some of these things. And if you want to reach out to Eric, I'll put his email on the screen. It'll also be in the description below. Now, if you're looking for some real estate help, whether it's buying, selling, or investing, and you want to talk to me, you can book a call with me using the link that's in the description. It's www.chatwithzen.com. I think I missed a W there. Anyways, yeah, www.chatwithzen.com. Until next time, your move, your future. See ya. Now that you're done watching this one, how about this one? Oh, you know what? This one's good too. Ooh, this one's really good. You know what? Just watch them both.